What's up? It's Dale with Flakedemic and Flakedemic.com, and today I'm here with
Nick Allen with Douglas Hahn and Heidemann.
Nick. Where's your office located?
Springfield, Missouri, in the Hammonds Tower.
Okay, all right, thank you. Can you tell me a little bit about yourself?
Yeah, so I'm a plaintiff's litigation attorney. I also do work comp. I've been practicing for almost 8 years now. Went to the University of Arkansas for law school and um, try and help injured folks every day.
Okay, and thank you for that. Thank you for that. And this is kind of what I'm doing. I want just to open some eyes to some things that people don't know or should be aware of out in
Sure.
the workplace and the workforce. I don't want. I'm not here to bash anyone or put names out for any companies or anything like that. Just information.
Un-
That's all. That's all we need.
Understood.
Okay. So I brought some questions with me that I hope you're able to answer.
Okay.
If you cannot, if you do not, just give me a thumbs down. You know
Okay.
what I'm saying? And I'll be like, okay, next one. Okay.
Okay.
Just don't punch me, dude.
All
Just
right.
don't
I
punch me.
won't. I
Okay.
promise.
Okay. All right. First question. In your expertise, what factors contribute to a lack of empathy or concern for employees in some large corporations?
Yeah. So I think the fact that companies are always looking at their bottom dollar is a big one, and the more empathy you show to an injured employee, typically translates to providing them more medical treatment, providing them more time off work, and all of those things cost the company money. Even if they have an employer, like in a work comp setting, if they have work comp insurance, um, their premiums for that insurance will go up anytime there's a claim, or if it's a large claim, that may affect the level of premiums that they have to pay in the future. And so, although they may have insurance, it's still gonna that cost is still gonna be transferred to the company. And then you have some that have their own that they provide themselves their own insurance, and so um, they directly see the costs that go out of their pocket for that. And so the way like work comp in Missouri works is that they are essentially immune from uh, how they handle a work comp claim. And so if they're not being held responsible for how they treat their employees during a work comp claim, then they don't have much incentive to do what needs to be done to get those folks the right treatment and get them back on their feet.
Yeah. Oh, ouch. I mean, ouch.
Yeah.
Uh, I've been through it. But I it's rough out here. It's really rough out here. So again, I want to open up eyes to these, and that's why I'm glad you're able to answer some of these questions because I'm still learning myself, and this is more information that I'm obtaining that I can try to give to the masses.
Sure.
If I can, that's my goal. I just want to spread some information and open awareness, or raise awareness.
Absolutely.
All right. So my next question I got for you is: can you discuss any legal loopholes or practices that allow big companies to mistreat their employees without severe consequences?
So I don't know if I would necessarily call them loopholes, but I would just call them protections.
Okay.
So in Missouri, uh, in the work comp setting, one, the employer is immune from civil liability in the court system, unless they intend to hurt you. And so that hurdle is really hard to overcome. And so uh, most most injury claims against employers has to go through work comp. And then, like I said before, they also have immunity for how they administer the work comp claim. So um, their their best approach, and when I say their best approach, the approach that typically results in the least amount of money paid out on an injured employee's claim, is to drag it out, to not provide all of the treatment that's required, because one, either the employee will get tired and stop fighting, or in the end they'll be able to negotiate something between what they provided and what they should have provided, and so it still results in them, being able to come out a little bit cheaper than probably what they should.
Okay. Okay. Thank you. Thank you. Are there? any specific industries or sectors where employee mistreatment is more prevalent among large corporations?
I wouldn't say so. I think the way I see claims being moved on the employer side, it's pretty consistent across the board. I represent folks from very small companies to some of the largest companies in the world,
Okay.
and what I see is kind of a pretty similar treatment of all of those employees. Now, some of the smaller companies will be a little bit more empathetic, I think, but
Hmm.
you still see issues with smaller companies, and employees being able to get the treatment and the compensation that they're entitled to. I think probably again it goes back to the insurance companies are the ones that kind of make a lot of the decisions as far as what's being paid out, what treatment's being provided, and so and then those insurance companies are being represented by the same attorneys,
Hmm.
and so you see a pretty uniform treatment of employees across the board.
Okay. Okay. Thank you. Thank you. Are there instances where inadequate labor laws or enforcement contribute to poor treatment of workers in big companies?
Yeah, I mean, I think that the way the system's set up in Missouri now, and work comp specifically, is that it provides a lot of protections for the employers. Um, like I mentioned, the civil claims bar that requires the employee to, in all but very few circumstances, take their injury claims through the work comp process instead of filing a civil case. That helps the employer because there's things like emotional pain and suffering that you might be entitled to in a civil case that you're not compensated for in an employment case.
Mm.
The other thing, like I said before as well, is the immunity that employers have for how they administer these claims. Because the way that plays out is if somebody's entitled to treatment for like a broken bone or something, and the employer doesn't immediately provide that treatment, um, say they dispute that the injury arose during the scope and course of work, that that employee will have to go get treatment on his own, or else it'll be months before you can even get an administrative law judge to order even temporary relief, ordering treatment. So that's another way that they can avoid having to pay out, because by the time they ultimately an employee, say an employee can't afford treatment on their own, gets an order from the administrative law judge ordering treatment, the bone's already been healed,
Yeah.
and so it does, although it may not have healed back appropriately, it's a situation where there's not really any other treatment that could be provided after that delay that was caused by the insurance company or the employer's initial position on the injury.
Okay. Thank you. That's just putting the employee just in a bad situation right there.
It does, and the idea for work comp is that it's administrative. It's supposed to be easier for the employee to obtain
Mhm.
a recovery, and in a lot of situations, you see employers where it's an obvious case. This is what they're supposed to do. They'll provide a lot of the compensation that the work comp claim or work comp statutes require. But if there's any way, any wiggle room that they can see, a lot of times they'll exploit that, and so it ultimately ends up in not being as employee friendly of a system as I think it was originally intended to be.
Mm. That leads me to my next question. We spoke about the ERISA rule. Can we dig into that a little bit?
Yeah, so ERISA is a federal legislation that covers certain types of health insurance, disability insurance policies that are employer funded, and those types of policies are generally given kind of what we think of as a super lien on compensation. Uh, so they have a subrogation right whenever you're compensated for, say, like uh, wage replacement under work comp. They potentially have, if you have a disability, income policy that pays you out during the time when you're maybe disputing with your employer about whether you're entitled to wage replacement while you're off work for an injury. They'll pay you, but then they'll pay you under that insurance for that lost wage. But then, if you ultimately are able to recover from the employer, then you may have to pay back a significant portion of what you receive from the employer because of the insurance policy's subrogation interest. And because that's federal legislation that protects those policies, it will preempt any state laws about attachment rights on like work compensation.
So this rule, this ERISA, like it's not here for the employee. It's more damaging to the employee, but it's more a safety for the employer.
I so I would say I see a lot of times it hurts the employees on the back end where they are able to get compensation for their injuries, whether it be from an employer or from like somebody that hits them in a car wreck or something like that.
Okay.
But there's a lot of other things out there that legislation does help. I mean, it incentivizes employers to provide health insurance and that type of thing because it gives them a level of protection.
Okay.
And that health insurance, employer provided health insurance isn't cheap for the employer. So I I would say there's a lot of ways that it can negatively impact somebody that's injured that has one of those policies, but there are also benefits to it, I would say.
Okay. Okay. And so you explained it a little bit more. Kind of make a little bit more sense to me now. Okay. Thank you. But it's still bad for the employee for me. Okay. Let's see. Can you provide any examples or situations of where workers' compensation doctors display a lack of empathy or consideration for the needs of a injured employee? I'm sorry.
Yeah, so I don't know if I would describe it as a lack of empathy, but we certainly see, in the work comp process, the employer or insurer will send an employee that's been injured to, certain doctors that you know will provide them a low disability rating after through their evaluation, and then a lot of times we'll send somebody that we know will provide a higher one. I don't know that it's necessarily a lack of empathy. I think it's probably more, the insurance companies, their attorneys know which doctors have certain more conservative, you could say, views on disability compared to ones who are more liberal in their evaluation. And I've certainly seen where administrative law judges they know certain disability ratings, like in a case where you have a broken uh, uh, a broken like spine,
Hmm.
broken bone in the spine, and you have to have like fusion surgery or something like that. I've seen doctors, rate somebody who's been through that at like a 10% permanent disability. Uh, and then, when you get in front of the judge, they recognize, hey, this opinion lacks credibility um, because this is something that should be higher, like a 25 or 30%
Yes.
disability rating. So it's something that we see. I don't know. I've never been able to quite put my finger on why it is that certain doctors are so conservative.
Hmm.
But I definitely see doctors that are too conservative in their evaluation beyond just hey, this is where reasonable minds in the field could disagree. It seems more like they kind of have an agenda to do that. What the reason is for that, I can't say.
Hmm. Okay. Agenda. All right. Okay. One more. Let's see. How can employee identify signs of mistreatment by their workers' compensation case manager, and what steps should they take if they experience it?
Yeah, so the work comp case manager it's an interesting cog in the workers' compensation process. A lot of times they act, they will represent to employees, say things that make the employee think that, hey, I'm here to to be your advocate. Well, they're paid by the insurance company, or somebody working for the insurance company, and really a lot of times what their purpose is to speak with the doctor about the recommended treatment, and what insurance wants to pay for and how they want to pay for it, and that will affect a lot of times how the doc what the doctor recommends. And that might not seem appropriate, but that's how our insurance and medical system works. Is that healthcare providers and insurance companies are continually collaborating on identifying the most cost efficient way to treat injured people. So I would say that the most important thing in any work comp case is to talk with an attorney.
Okay.
Let the attorney know what your interaction is like with the work comp case manager, and then the attorney can either take steps to talk to the employer, their representatives, or in the appropriate circumstance to the nurse case manager, and let them know, hey, here's the things that we think we don't appreciate how this is being handled, and so we'd like it to change. But anytime there's an injured worker, I always think, even if you don't hire an attorney, it's important to talk to an attorney, because there's so many ins and outs and rights and obligations and responsibilities that the average person probably doesn't know, that an hour-long consult with an attorney, even if you have to pay for it, will be worth a lot.
All right, thank you. I got another one.
Okay, that's all right.
So the word negligence.
Yeah.
Why is it so hard to prove negligence when it comes to cases with employees getting hurt and things like that? Like, why is there a word negligence, but you can't prove it?
So the word negligence, when you're dealing with an injured employee who's injured on the job, like I talked about earlier, there's a work comp claim bar that prevents you from being able to bring a civil case against your employer in circuit court.
Mhm.
Um, and that's another thing that's intended to help the employee out, is that in a work comp claim, you don't have to prove negligence of your employer to be able to be compensated for a work injury.
Mhm.
You just have to prove that you were injured during the course and scope of your employment, um, and you're entitled to compensation. Uh, so in the work comp setting, you don't have to prove negligence. And then in order to get your employer into court for an injury, like I said before, you have to actually prove intentional conduct by the employer intending that you are injured.
Mhm.
And so that's a lot higher standard than what negligence is.
Yeah.
Now, one of the things to keep in mind is that if you're injured at work, but you're injured by somebody that's not um, an employee of your employer, so maybe it's not a coworker, maybe you're in a warehouse setting where a dock worker is injured by somebody unloading a truck for another company,
Mhm.
right? So you may have a claim against that other company who employed that person that threw the bag of whatever on your ankle and broke your ankle. Um, and you would also have rights under the work comp uh, law against your employer. So it's important to identify potential ways to be able to have a claim in circuit court against a third party where all you would have to prove is negligence. But to really answer your question, I mean, negligence is that your conduct, it was foreseeable that your conduct would provide or would cause injury, and as a result of that foreseeable conduct, injury was proximately and directly caused by that conduct. So, a lot of times it wouldn't be hard to prove employer negligence, but the work comp claim bar prevents you from having that opportunity in circuit court.
Okay. Okay. Thank you. Is there any information you can share with the average employee out here? Uh, anything you want to like share?
Yeah, I
Yeah.
mean, the most important thing when you're injured at work is to immediately notify your employer and to go talk to an attorney. There's minor injuries that that it's not going to be worth filing a work comp claim for. But I think it's important to report any injury, because even a small cut could result in infection
Yeah.
that could cause significant injury. And so, if you haven't, especially in Missouri, if you haven't informed your employer in writing of your injury within 30 days of the injury, but the real damage from the injury doesn't start manifesting itself until more than 30 days after, you may be in a position where you're not entitled to a claim under work comp, because your employer was prejudiced in not being able to get you treatment, antibiotics for the cut, at the beginning of the process. And so, even though you have an injury that resulted in a lot of medical treatment down the road, you may be precluded from making a work comp claim, because you didn't provide that statutory notice within the 30 days of the injury. So, my biggest thing is, if you're injured, let your employer know, and then talk to an attorney.
Okay, there you go. Report it. You hear it first. Okay, thanks, Nick. I
Yes, sir.
appreciate your time, man.
Yeah, no
All right.
problem.
Can you let the people know where you located, and one more time, just
Yeah.
information?
So Nick Allen, I'm a partner here at Douglas Hahn and Heidemann in Springfield, Missouri. We're at 901 East St. Louis Street, Suite 1200 in Springfield. That's Springfield, Missouri 65806. It's the Hammonds Tower, 12th floor.
You got it.